One of the most common questions we get is on due on sale, and everybody is jittery about that. Now, due on sale comes into play when there's an existing mortgage on the property is sold, and that lien is left in place. So let's just take a minute and ask, what is due on sale? So due on sale was originally created so that if someone sold their property, it could be residential property or commercial property, and there is a due on sale clause in the mortgage. That means the security instrument. The lender would ask you to pay off the loan. That makes sense. Now, if you sold your house for cash, you should pay off your loan. Now, over the years, that's kind of changed a little bit, and lenders, in order to control the transaction more, have made changes to due on sale. If you sell the property using, let's say, a subject to or a wraparound mortgage, they can call the loan due because it's changed hands. If you sell the property using an executory contract, they can call the loan due. I've seen some due on sale clauses that if you lease the property for a term of more than 3 years in running fashion, they can call the loan due. If you have put the property into a trust and you convey the beneficial interest to a third party other than the borrower, they can also call the loan due. When you look at that, guys, the way I approach that is it's all about control that the lender wants to have. Keep in mind, the original borrower is still liable on the note. The lender is still in the proper lien position they've been in. Now they've got a secondary source of repayment, but for whatever reason, they simply don't care. So when you look at due on sale, the question is what causes it? And there's many things that can cause it, such as the conveyance of the property that is picked up. Lenders don't often look in deed records. They don't look on the county appraisal district to see if there's been a change of ownership, but they could. Maybe when they get their tax notice sent to them by the county where the property is located, they see a different owner. Could that be a cause? It could be. Insurance can be a big issue because lenders want their insured to be named as a primary insured on an insurance policy. Whoever their borrower is, they need to be listed as an insured or as an additional insured, or they'll kick it out. And so if your insurance doesn't have that when they get it, is that problematic, and could they research the transaction? They could. Slow pay could cause them to research the transaction. Non-payment could cause them to do it. And guys, in reality, it could be anything. Now, the United States has a federal bill called the Horne-St. Act that was created back in the early 80s to allow a homeowner to convey their property into a financial planning trust. Now, that's not necessarily a land trust, it's a financial planning trust. A lot of investors utilize a land trust to buy homes this way, and some think that that may take the place of a financial planning trust. Now, what the lender does not know may not hurt them, but in reality, that is not technically a financial planning trust. Also, if that trust was not originated in the name of the original seller and the owner of the property, and you've just created a trust, call it 123 Land Trust, the question becomes, if a lender was to read it, what would it look like to them? So it's important to make sure your transaction in regarding a trust is set up properly and you understand those kind of items along the way. So what happens if you do get a due on sale letter? Well, a lot of investors and note holders, buyers, sellers, they get nervous really quick thinking that they have no time to deal with it. Typically, you have 60 days, 90 days, 180 days. You've got plenty of time to navigate the issue. And there are various ways that you can navigate that along the way that might allow the transaction to keep moving forward. Now, even though there might be some creative ways of doing that, there is never a 100% guarantee that it will work. There is always a risk associated with due on sale from any lender's perspective. And guys, the lender could be a traditional mortgage company, which is where the great majority of this comes from. It could be a small institutional bank. It could even be a private lender who put a due on sale clause in the loan. So oftentimes, if you have a transaction where an existing mortgage is going to be left in place and there is a due on sale clause in there, can you get permission from your lender to do the transaction? Now, the answer is maybe. And what I'll tell you is that with most traditional mortgage companies, the answer will be no, because if they tell one person yes, they got to tell everybody yes. So does it mean that you can't ask? Absolutely not, because it is possible that they could say yes. With an institutional bank, your small lender, I like to tell my lenders right up front what I do and how I do things and get their permission from day one. Also, with my private lender, I want them to be aware of that too. And usually your smaller commercial banks, your private lenders, aren't too worried about it. So if you were to get this due on sale letter and you did nothing, the lender or their attorneys are going to notify you on several occasions, not just one, about it. And if you fail to cure it, bottom line is, what are the consequences? Well, the bottom line is they could call the entire loan due, whether you're current in your payments or not. And that means they could accelerate the loan and post it for foreclosure. Now, every state is going to be a little bit different on due on sales. Here in Texas, the contract is going to govern. I've heard there are some other states out there, again, Arizona being one of those, where if the lender has not been harmed by the transfer of the property, in other words, their financial position has not been impaired in some format, they may not have the right to call the loan due. So you've got to know what the laws are in the jurisdiction where you're located. So do take a moment, talk to that knowledgeable attorney in your state, know what your state laws are about this. Now, due on sale, does it really happen often? No. Why? Because lenders really are in business for one thing, that is to make loans, to service the loans, and to collect their money. They're not in the real estate business, and they don't want to foreclose on the property. Lenders, oftentimes when they foreclose, lose tens of thousands of dollars along the way. They're not in that business, but it doesn't mean that they can't or they won't. A lot of investors think that when interest rates are really low, lenders, and they have now gone up, let's say, so maybe they have a 3% interest rate loan and the new rate might be 7%, let's say, that lenders see that and they want to foreclose so they can put their money back out at a higher interest rate. Well, oftentimes that is just not the case, because that has already been placed on a long-term basis and they're now servicing the loan. They've made their money. They don't want to go back out and recreate the wheel again with that particular loan. As an investor, though, a lot of private lenders and investors who do lending may see the situation differently, because they are going to have limited access to that capital and they want to redeploy it at higher rates. So it's important to know who your lender is, read the due on sale clause, see what it says, check your jurisdictional rules and regulations and what you must contend with in the state where you're located. Understand the consequences, understand there are ways to navigate it that are, for the most part, successful, but not always. And like anything else in real estate, and especially in creative finance, there are always issues that we have to make sure we disclose properly, we understand properly, and then navigate properly. So guys, if you like this video, take a moment and like us. If you want to learn more about creative real estate and creative finance, take a minute and visit us over at theownerfinancenetwork.com.